Well, here we are at 4 o'clock, so let's get started. Welcome, everyone, and thank you for attending the Birding and Wild webinar today. We're here for two really important topics. I'm Jill Jackson. I've been running the marketing and client relations stuff for Birding and Wild for close to 10 years now, and I'm also a condo owner and a board member. And the two issues that we're going to cover today hit really close to home because I'm personally experiencing both of them. So a little bit about Birding and Wild for those of you guys who don't know. We've been around for nearly 40 years. We cover pretty much the breadth of what it takes to be an HOA and help on the legal front with that. We've been advocating for years and years on behalf of homeowners and the associations, and now is no short of that. So I'm joined today by three of our partners. First of all, Tyler Birding is here in the room, and Tyler was one of our founders, and he has a long history of advocating on behalf of associations and homeowners, and he understands kind of the history and the evolution, and he's going to share a little bit about that so we can understand how we are where we're at this point. Then we've got Ann Rao on today. She's one of our partners who does a lot of appellate work, and Ann has been really integral in helping to provide edits and language and redrafting to try to get some of these bills where they can be hopefully acceptable for homeowners and homeowners' rights and protection as it pertains to construction defects. And then we're also joined today by Principal Jasmine Hale, who runs our corporate counsel department, and she's so involved in the day-to-day needs of HOAs, and she's going to help us to shed some light on what's going on with SB 1007 and how do some of these things play together. The 1093, 1007, do they interact with each other? I, as a homeowner, think I can see how it will in my universe, but let's explore that. We're going to start off with Tyler Birding. Give us a little history.
We have a lot of years that have led up to where we are today. Back in the Pleistocene, construction defects were not the subject of very much legislation. The lawyers that practiced that, us and others, and lawyers on the defense side representing developers, had to kind of make it up as they went along. The rules were not very well defined. What was a construction defect? What amounted to something that was actionable by an aggrieved homeowner or an aggrieved homeowners association was not real clear. In 1969, a case called Kriegler versus Eichler established the principle that developers were strictly liable for construction defect. What does that mean? That means you no longer had to show that somebody negligently put the building together, but that the building was built with a defect in it, regardless of how it got there. And that opened up a path for homeowners to litigate, if they had to, the construction defects in new buildings and homeowners associations as well. Of course, the building industry didn't like that very much. They felt that opened up their liability without any proof of fault, which is what strict liability is all about. But yes, nevertheless, homeowners were finding defects in their buildings. Very difficult to prove exactly how they got there, but they're there. A roof leaks because the water's coming through. That firewalls aren't in the attic because you look up there and they're not there. That a building may not be structurally sound if the shear walls are missing or not built right. So strict liability allowed practitioners of this kind of claim to advocate on behalf of homeowners and homeowners associations, using the existence of the defect itself as the basis for the claim. That worked for a few years, and the builders, of course, not like that, but they raised another issue, and their issue was, well, look, okay, maybe there is a defect there, but we should be able to come and fix it. We want to be able to fix it. We want access to the building so we can come and fix it. And they were running into some roadblocks, partly because the homeowners said, well, you had a chance to build it right in the first place. Why didn't, how do we know you're going to fix it right? And a lot of issues over releases that might have come out of that. But that was a main point that the builders were pushing at that period of time. And then came along another case about 1998, Oz versus Superior Court. That's AAS versus Superior Court. Oz turned the whole thing on its head and basically said, no, sorry, you're not going to be able to litigate these claims unless you can prove that the defect itself caused damage to some other portion of the building. And which really made it difficult to litigate or to make claims for things like I said earlier, missing firewalls, missing shear walls, things like that, because you had to wait for an earthquake or a fire before you could prove you were damaged. And of course, in California, there's an outside limit of 10 years to bring a construction defect claim. And if you found that if you had the fire in year 15, it was too late. You couldn't bring a claim against a developer. So basically, Oz immunized developers from life safety issues that would not yet had a catastrophe occur. So getting to that point, what the builders wanted access to fix things, the homeowner claimants wanted to be able to prove a defect existed and litigate it without having to wait for the earthquake or the fire to cause the damage to the building. So everybody sat down in early 2001 and began negotiating with the help of the California consumer attorneys on the one side and the California Building Industry Association on the other. And we negotiated that for well over a year to come up with what everyone still calls SB 800. I'll call it the Right to Repair Act because that was its other name. And it gave the builders a right to repair. It specified very clear pathway for them to come in and fix whatever was being claimed was a defect in the building. And on the other side of it, the homeowner claimants were given 45 very distinct standards of what is a defect. Everything from water intrusion to missing firewalls, to missing structural components. All of those things are all spelled out. And those of you who are legally inclined, Civil Code Section 895, 895 and 896 and thereafter. You can tell I don't pick up the code very often, sort of ingrained in me. Anyway, 896 spells out the 45 standards that builders must meet in order to avoid construction problems. But more to the point, it defined what a defect was, and if it's there, then the builder was liable for it. And that was a grand bargain that was struck between the Building Industry Association and the consumers of new homes and their advocates, and has worked reasonably well for the last 25, 26 years. Given the opportunity, the builders were happy to pick up the gauntlet once again this year and convinced the legislature to introduce SB 1903, which basically reintroduced the Oz standard again and pretty much wipes out all the other standards that we have had the benefit of since. And we're going to talk about all of that in a little while. But that's the background, and I wanted to give everybody a little history there.
And Tyler, when SB 800 or the Right to Repair Act was conceived, didn't the homeowners concede to shorter statutes of limitations, shorter time periods as a concession to that period?
There are two that were already there, or three. The outside statute of repose is 10 years from various dates, but mostly from close of escrow. For defects that you don't see when you move in, we call them latent defects. Patent defects are 4-year statute of repose, which those are obvious when you see them. But in addition to that, the builders wanted additional ones added to the standards. And some of the standards have shorter statutes of repose, from 5 years down to 1 year, depending on what the component is. So they got that as well in terms of the negotiations that we did back in 2001, 2002.
So Anne, how do you see now what's written in 1903 and how's it going to change from where we've been at with the SB 100 right to repair?
That question, Jill, is actually a good place to start because as you were asking it, I pulled up the list of the shortened statutes of repose. Firstly, just to provide an overview and for the benefit of our listeners, this bill has been on our desks for many months, and it's gone through many revisions, as Jill alluded to, focusing. So there have been it's been improved by about 10%. The biggest problems with the current bill, because there are plenty that I'm not going to talk about. There are a lot of ticky-tack changes to the notice, and if any managers are on here have been through the process, you know there's a pre-litigation notice that has to be given, and lots of what I would consider ticky-tack changes have been made to that process that the developers and the building groups have pushed through. We haven't fought on a lot of those kinds of things. The biggest problem with the bills can be boiled down to maybe 2 or 3. And Tyler was just talking about the property damage component. So one of the biggest quid pro quos, as they say, are the trade-offs during the negotiation of the Right to Repair Act back in 2002, was these multiple shortened statutes of repose. In some cases, the really important ones are 4 years from date of close of escrow. All of these standards of construction that Tyler just talked about in Civil Code Section 896, there are about 48 of them, and they're nauseatingly detailed. And every time I get a new case, I always have to look through that statute again to reframe, okay, what am I looking for? What are the statutory standards of construction, as they say? We went through that list of defects, and most of them, because the whole purpose of the Right to Repair Act and current California law was to be protective of property, to protect against damage, to protect consumers against the eventual destruction of properties. These can lead to catastrophic failures, and oftentimes they happen, in years 8 of the property. They don't happen overnight. So you buy this nice, new, shiny home, and you walk into it and you expect it to perform pursuant to all these standards that you're expecting the law to guarantee because they're in the civil code, and oftentimes developers even include reference to all that in the sales materials, and you trust developers. You don't expect that at year 8, there are going to be, you're going to see the buildings starting to move, crack, there's seismic, as they say, structural deficiencies. They start to, what I would call season. If anybody cooks with a cast iron pan, I have to season that pan. Well, a building doesn't season in the first few years. You don't see these defects. They're hidden largely. So the biggest problem with the current proposed legislation, AB 1903, is that it's bringing back the Oz rule in the context of all of these really short statutes of repose that are still going to be part of the law. As if AB 1903 is approved, we're still going to have really short statutes of repose, because the principle behind the current law is that you don't have to prove damage. You don't have to prove that the building has already burned down because of the electrical deficiencies or the electrical code violations, or you don't have to wait for the earthquake to happen. If you can identify early signs of anything that would tip off these deficiencies, you can initiate the repair process. And by the way, the developers have always had the right to repair since the beginning of time. Through the warranty process, they had the opportunity to build it right in the first place. And there is no association that I'm aware of that would preclude, if the builder came in and wanted to repair under existing law or even prior law, if legitimate repairs were offered full repairs that would, eliminate the need for litigation, which is long drawn out. Nobody wants it. But if legitimate repairs were offered, associations and most attorneys, we would recommend it. It would be in the association's best interest to get that done without need for litigation. The problem is, when the fox is in the hen house, so to speak, and the developer who didn't do it right in the first place, if you have a legitimate defect, who's to say that the developer should be in charge of the entire repair process? And that's what AB 1903 does. It puts the developer in the driver's seat, both by eliminating an association or a consumer's right to recover the cost of expert investigation. No longer, under their proposed revisions, no longer would that be an element you can recover. So you'd have to, on your own dime, without any hope of ever recovering it. You can't even hire experts to investigate the building, to advise you on what an appropriate repair would be. It's all up to the developer who screwed it up in the first place, right? So you have to trust that the developer is going to do it right the second time when the repairs are happening, which is always more complicated anyway. So under AB 1903, I think I will just sum it up because I heard some skepticism that I was going to get through this in 5 minutes. I'm going to. I'm going to do my part to try to keep us on track. But the big picture is that what's happening with AB 1903 is that all progress that was accomplished in 2002, which was, again, protective of the property, to make it so that you don't have to wait until the earthquake. You don't have to wait until the devastating catastrophic fire occurs because of the code violations, and et cetera, plumbing deficiencies that can, result in catastrophic losses too. People think plumbing problems are just tiny leaks. Well, if there's a real significant venting problem, anybody with a plumbing background will understand a venting problem causes sudsing, causes black sludge into units and homes. And when that happens, sometimes in year 6, it can result in hundreds of thousands of dollars of damage to your belongings, to the home. And so having the right to pursue those kinds of repairs early, protectively, prophylactically, as they say, having that taken away the way the legislature is currently proposing under AB 1903 as reform litigation is outrageous, because it forces homeowners into a corner when they've already put out they've paid, these homes are not cheap. They're putting their life savings sometimes into these homes. And if there are significant defects, which we're going to get to when Jasmine starts talking about the flip side, I think there is a connection between the two bills right now, and certainly when it comes to community associations, but to create an environment where the developer has control over the product that's put out there. We know that. They always do. That's how it works. Developers put a product out there on the market, but to insulate that developer and to give the developer basically the right to write all the rules around what happens if something is built wrong. They get to control the entire process. You can hire your own experts, but you're going to have to do it on your own nickel. The developer will not be responsible to reimburse that, which current law requires. Obviously, it's an element of your harm to have architects, engineers actually scrutinize the repairs. I call the repairs that often happen in these pre-litigation processes, they're Band-Aids. Often developers, they come in and they will put a Band-Aid on, and what AB 1903 proposes to do is to preclude homeowners and associations from holding the builders accountable for good repairs, for quality repairs. Wow. And so to me, that's the most outrageous. There are other problems with the bill that could take us longer than the 5 minutes, since I was challenged to the 5-minute limitation. But we don't need to go into all the details, but I think the biggest problem with it is that it's going to force consumers into a corner, prohibiting them from pursuing. And there's one other detail that I'm not going to get into the lawyerese about this, but when a claim, or if this bill passes under the way it's currently drafted, and believe me, there's a lot of negotiation, as Jill alluded to, that's still happening, and we're trying to fight back and trying to make it a more reasonable law. So a lot of the things I'm saying right now, hopefully, won't come to pass, because we are still fighting with everyone to try to make sure that this is a fair law before it's passed. Right now, it's not a fair law. Um, but
So, you
currently,
know what, Anne, like, just to distill it down for, managers or board members, like the grotesquely offensive part, there's lots of them,
yes,
of 1903 is that it's a builder's immunity bill.
really
It,
is.
it,
Thank
it,
you.
it literally, like, it allows them to create a certified building process that they get to write the rules for, and then they get to pick the inspector of their choice, who the statute literally allows the builders to have a stake in, just can't be more than 10%.
Yep.
And those handpicked inspectors, when they say, oh, do A, B, or C, and they're being hired by the developer to give the developer the list of things. You're gonna get lipsticks on pigs here, folks. Like,
Yep.
if the windows were installed without flashing, and that means in, normal people world, your windows are gonna leak. If the building, inspector's like, oh, you can fix that with caulking. That's BS. You can't. It's gonna leak again every time the caulking fails, because there's no flashing. Water's gonna go into your unit. And like, the developers get to pick the person who gives them the list. And as soon as they fix the list that their handpicked person gave them, they get complete immunity. You cannot,
Yes.
like, as a statutory matter, it's called a 15.
Let me distill it down even a little further than that.
Yes.
Some real practical examples. Let's say you just move into your new condo in May, go through the summer, it's dry, nothing's happening. Comes October, it begins to rain. The inside of your window, inside, not outside, water is dripping down from the inside of your window. Oh, you're gonna put a towel there on the windowsill, you're gonna soak it up, and you say, well, this shouldn't be happening. Okay. And you call the manager for the homeowner association. They say, oh, other people have been saying the same thing in other buildings. There's a few of these leaks around. This is a leak, okay? That at that point in time, because the homeowner has done what they should do, they're mopping it up, has not caused any damage. An ordinary garden variety leak, the homeowner would not be able to assert that claim against the builder under this new law. That's one example. Take another one. Let's say your toilet doesn't flush because the sewer pipe is pinched somewhere down the line. You don't know where it is. Okay, it hasn't caused any damage to any other part of the building, but it won't flush. It doesn't work. Builder's immunized. Builder doesn't have to respond to that claim because it hasn't yet caused any other damage. Those are the kinds of things, and that's before we get into all the life safety issues. There's about 19 of those standards that are clearly there to protect life and safety for the homeowner and the occupants. Most of those can be existing defects without any associated damage, because we said before, the fire hasn't occurred, the earthquake hasn't happened. But of those 19, none of those could be claimed as a defect under this bill.
Right. The new law, actually, I'm reading from the proposed language right now. You raised a really good point, Tyler, because you're talking about a leak happening and it's, on the windowsill, but it hasn't happened long enough to cause what the law is, or the proposed law is saying, that it should have to cause, the language they're currently proposing is that it would cause appreciable, non-speculative, present physical damage to another component part of the building, which means it has to get into the framing. You have to show that it's rotting the framing, even though we all know that it shouldn't be leaking onto the windowsill. That's a bad sign. The worst part about it is that under the current law, an association or its members can't hire an expert to come in and take a look at that. So under the proposed new law, they're talking about no extrapolation. That's a big word for people who don't get involved in these cases. But what that means is that you can't, if you know that 5 windows have leaked, and it's likely that it's going to extend to the rest of the project. The way the current law is drafted, it would mean that you would have to test and prove that the framing and other things, you'd have to do the cost of it. You'd have to investigate by doing destructive testing to prove what you already know is likely happening, right? The leak is going to cause, if it hasn't already, damage to the building, the framing. You'd have to prove it at every single location. You can't predict the rest of the project anymore. So there are a lot of other things. So that's called extrapolation, also written out of the rules by the developer sponsored bill here. It goes on and on. The injustices are large. So I think the point of this entire discussion is to well, obviously to inform the community on what is happening in the legislature. And Jasmine's going to talk in just a minute about how, this is obviously going to cause financial devastation to an association. If an association has to absorb the cost of repairing significant defects for which the association is normally responsible for, the roofs, the exterior, the big ticket items are normally on the association. I would like to talk to Jasmine. I'm going to turn it over to Jasmine to talk about another thing running through the legislature right now that is going to materially impact, really, I would think, throttle associations' ability to function under these circumstances. What's going on?
Good segue, Anne. So that is referencing Senate Bill 1007 from Senator Menjivar down in the Burbank area. So, I joked earlier today with some colleagues on a Zoom. I was like, well, none of us can drive by our house and throw tomatoes, but if we want to sponsor a bus, let me know. No, I'm kidding. But so SB 1007, it's like Assembly Bill 1903, it's sort of being billed as a, housing affordability measure. It doesn't do that, but that's kind of under the guise of why it's being, promoted. It has three different, very disparate components. The first component is changes to the association annual budgeting reports. It's trying to provide information that the association homeowners already have a legal right to request. So I'm not sure if shoving the budget versus actual report from the prior year into the annual disclosure statement that almost no one reads is going to help inform them. But I guess, hey, there you go. It's going to be in there. It's also going to require a separate statement about all the compensation provided to management companies. Again, this is information that's already knowable and accessible to homeowners. My concern about providing the information in the annual budget report is that it may lack context. You could sit there and say, okay, a management company collected $60,000 in fees for the year. Well, sometimes homeowners don't appreciate nuance, right? That doesn't mean Jasmine, your community manager, received $60,000 from you. It may mean we had project services, printing and mailing costs, a lot of different sources that paid the management company. So I fear that it could paint a target on the community manager's back because homeowners don't appreciate nuance all the time. But that's not the, crazy offensive part of the statute. Then we get into the second component. It would modify Civil Code 5605 for the legal nerds in the room. And it would impose a cap of 8% on assessment increases. So since the beginning of Davis Sterling back in 1985, when it was passed, the cap has been for, what are we at, 40 years on the nose? It's been 20%. An association board of directors could increase regular assessments up to 20% from the last year's regular assessments without a vote of the membership. This would lower 20% down to 8%. And, the really complicated issue with the 8% is that it doesn't factor in, well, what about utilities that have been increasing to 20 to 30% year over year for several years? What about insurance? Same increases. And so you've got all right,
the legislature clearly doesn't appreciate that associations operate on $0 budgets. If, you know, our landscaping company and the utility providers and our insurance carrier and management, all that combines, and we needed to raise dues to cover those fees, you know, 12%, 4%, that's the number that the associations will typically increase their budget, because they don't operate on a profit basis. Like, if we needed to collect $150 per person per month, that's what we collected, because that's the number that we spent. And so this imposes a sort of artificial cap, and it doesn't really leave a lot of great options. I had a manager earlier ask, so like, what do we do then if, you know, utilities and insurance combined are going to raise over, you know, that 8% cap? And what happens if our homeowners, and we send it out for a vote, what if they vote it down? Would we not have insurance? Do we allow the electricity to go off? Like, it's not an acceptable response. I said, well, you're either going to go through some, you know, contortions on approving emergency assessments and risk that homeowners are going to challenge those, because you know, there's an argument that I could make that we could like squeeze it in there, but it's not a pretty argument. Or we have to go the court route and like try to get the court to lower percentages and whatnot. Either way, you're increasing costs. You're having more legal fees. You're having additional elections. All that stuff is absolutely contrary to the objective of the statute, which is we're trying to lower, you know, affordability. And right, just because you cap costs at 8% does not mean you're lowering affordability. Like, if you actually want to address affordability, start going after the insurance carriers, set utility rates, set rates. Like, there's a lot of things you can do to actually address affordability, but just setting an artificial cap is not the actual solution. So
someone commented on here, insurance increase of 400%. Yeah, those are realities we've been seeing. And there's a lot of good questions coming through, and we'll circle back and get to those.
Exactly. And then that's the second part of the statute. That's the one that has a lot of people abuzz in the industry. And then the third part of the statute, again, this has zero to do with affordability, is that for violation hearing processes, it will impose some new requirements on, you know, digital evidence that's that's going to be used, you know, certain number of days, 5 business days before a hearing. You would have to provide not only the digital evidence, like the photograph or the video, you'd have to provide the metadata. I didn't even know what metadata was. I had to go Google it. And then I was like, where the hell is the metadata? Like, it's the background information on like the pixels and the date and time things were done, location. I'm like, you know, good luck with that one. If the association has that information, if they don't, you know, they're risking having their, you know, violation hearings overturned. So it's just making an already process that's challenging and complicated that much more so. But, you know, to tie the part of 10007 that I think really does also, you know, directly involve 1903 is that, you know, you're going to have community associations who they're not going to have enough money to do inspections. If you're a new build community, because now you're artificially limited to 8%, and you're like, all right, well, we think there's like things afoot here, but we don't have enough money in the budget and we can't raise it anymore. Like, so we're just not going to look into stuff.
Well, even forgetting about looking at new stuff, what about stuff you already know about? What about those leaking windows that we talked about in 8 of the 15 buildings? The Homeowners Association, regardless of what happens with 1903, the Homeowners Association is still responsible to repair leaks that occur from the outside in a condominium building. And
the single most valuable thing that an association has at that point in time is its ability right now under existing law to hold the developer accountable to fix those, because the law still, you know, this is all about the developers wanting to fix it. The associations would love that.
Take your choice. You can either pursue the builder under the current law, or you can pursue your homeowners for the cost of repairing all those windows. And even if they're not in their own unit that's leaking, if somebody else, other buildings, the homeowner association is responsible for the maintenance of the structure, and that would include any leaks like that. These are just one small example. I could give you dozens of them that are like that. But if the builder can't be held responsible, if they're immune from claims like we were talking about, then guess who gets to pay for it? The only person left to pay for it is the homeowner, because the homeowners association has only one source of funding if this bill passes, and that's the individual homeowners.
And I mean, the tough thing about 10007 is that 100% certainty. That's not 92% certainty. There's 100% certainty that the place where associations, because you're like, well, the gardeners cost what the gardeners cost, and the insurance and the electrical, they cost what they cost. The place where associations are going to shave so they can fit within the 8% is from their reserves. And what that's doing.
None of this sounds like it's making housing more affordable.
No, well, someone asked that, where are these bills coming from? And they're both coming from legislators saying, oh, we're going to make housing more affordable. And I guarantee you, none of them live in a condo, an association that's had to deal with these realities. I mean, I'm certain a lot of people out there who've gone and bought their place, you, just like I did, you pour everything that you have into getting in that place. If I would have had to be specially assessed $20,000 2 years into owning my condo, I don't know what I would have done.
Yeah.
I was lucky that I wasn't subject to the new proposed 1903, but I myself would have been up a creek. Yeah.
The fact is that the homeowners associations have become the quality control for a lot of these condominium buildings, not the builder. They pass on the defect. The homeowners association is then stuck with the quality control responsibilities and the repair of any of those defects. The only way they can get a decent amount of funding in order to repair some of the major defects is to go back to the builder and get them to contribute. This bill will pretty much remove that possibility on most of the significant defects.
And what's offensive to me about all of this is that the builders have created this apparent narrative that's landed well with YIMBY groups and, certainly Assemblywoman Wicks. And they're like, oh, but if only, we didn't have these expensive defect lawsuits. Do you know who pays for the lawsuits? It's not the developer, it's their insurance carrier. You know who pays for the insurance? The homeowners that bought the units. The developer doesn't pay a dime for this process. And it's offensive that you're like, okay, do you want to know how much developer insurance has gone up over the last year? There's an article about it yesterday, about 1 to 2%. Do you want to know how much labor and material costs have gone up over the last numbers? 20 to 30%. So you're trying to sit there, bend your homeowners over and take the one source of remedy that they have, shove that back on them while the developers get to go and become even fatter and happier. There's a reason why Berkshire Hathaway bought Taylor Morrison a week ago. It's not because it's a struggling, dead entity. It's because they're making bank.
Yep, you just nailed it, Jasmine. That's exactly, as I was listening to Tyler talk, that's exactly who benefits, the insurance companies. And ironically, it is built into the purchase price of every single condominium that's purchased. The insurance is baked into the purchase price. It's there and it's available, and it's what responds to the claims. So it is really it's outrageous to suggest that these combined bills are going to create more affordable housing. It's really only lining the pockets of the insurance companies ultimately.
Well, you have to also ask, because I see a question popping up, is that what's the justification for 1903? And the builders will say, well, it's costing us too much money to build condos because of all this construction defect litigation, so we're not going to build condos. Well, they're not building condos not because of that. They're not building condos because interest rates have been higher than a kite for the last almost 10 years, since they were in the low 3s and now they're up well over 6. They can't find land. Cities won't allow them to build in certain areas. The state already is pushing back on cities and counties to force them to find more spots to build affordable housing. That is a well-recognized problem that's floating everywhere. There are plenty of reasons, and if you wanted, one of our partners has gone back and looked at the corporate reports, the financial reports for a lot of the big national builders, and the cost of construction defect litigation is in the very low percentages. They're minimal percentages. They report that, but then they have they've convinced the legislature that, oh, well, it's really a big deal. And so we need this bill to gut the ability to sue it. So if you can't hold the developer responsible, guess who, there's only one entity left, the Homeowners Association and its owners.
Yes.
You know, so one of the questions on the Q&A is, does this just apply to condominiums, the 1903 statute? No, it applies to all construction. Residential. So it's not limited to just condominiums. It's to your, you know, planned developments, your single family homes, your townhomes. So it's a equal opportunity offender. And, you know, the question, you know, we can pivot, like, what do we do to fix this? And, you know, we've got, like, I'm grateful that we have Anne, who's been working very carefully and closely with the Consumer Association, the Consumer Attorneys Association of California, you know, also Community Association Institute. So many letters, folks. It's late in the day. You know, that we've got advocates who are directly engaging with the legislators, but the best thing that every one of us in this industry can do is engage with our legislators. Like Buffy Wicks is my legislator. You can damn well guarantee that she's on the ballot right now. And you know, you sit there and you say, all right, well, I'm having a neighborhood party on Tuesday, and I get to talk to my neighbors about this and explain to them, like, hey, these things are out there and percolating. But there's, how many people are on this call, Jill? Like 200, 150, something like that? Okay, that's a lot of people who have legislators. Go and, you know, go to the birdingwild.com homepage. There's literally like a little link right there on the homepage that you can click. And it's like a click and 22 seconds so that you can type in your name and your zip code. And it'll like tell the legislator, we think this law sucks, please vote against it. Yeah. All of us are from all over the state. It's not just Buffy Wicks and Assembly District 14 that matters here, because right now the law is over on the Senate side. It's passed the Assembly side. So now it's been referred to the, what is it, and the Housing Committee or just the
Judiciary Committee? Yeah.
So it's in the Judiciary Committee right now. And those members on the Judiciary Committee, they're all over the state. And so you may live in Nevada and your, you know, senators on that committee, you go and register your, I object to this statute, that makes an impact on them. And so that's the number one best thing that all of us kind of rank and file people can do right now. Send an email, you know, through our system. It's super easy to do. It's got a special widgets that like know how to direct you. Call your legislator. That's even better. Like, give them a call, send an email for sure, but call them and be like, this is a garbage piece of legislation. Like, why are you trying to harm consumers? Post it stuff on your, you know, LinkedIn, tag your legislator, be like, I totally oppose this.
The legislators can hear from the lobbyists and the lawyers like us all day long. They'll listen to it and they'll take a lot of it in, but nothing has an impact like homeowners in their district, calling them up, writing them, or appearing at their office, or appearing at a hearing in Sacramento, which we could invite, many people would like to come to go.
June 30th.
June 30th.
That's what makes a difference.
Yeah, we have a couple of questions regarding this. So a lot of it, all this kind of information is available on our website. We make it really easy to find your legislator. We make it really easy to click the button and send a letter to your legislator. Can we have access to this recording afterwards? This will be on our homepage of our website by Friday. So find it there, share it with everyone that you can think of. It's really up to kind of all of us who are, you know, have an interest in having our rights protected. So all those kind of activities. And I'm looking at some of the questions. What can we do to make our concerns known? Just that. So the next stage that you were talking about on the 30th of June in Sacramento, we have a bus that you can get on and ride with us for free. It's meeting at the Walnut Creek BART station at 7 a.m. We'll have food, we'll have raffles on the bus. We'll try to make it as fun as humanly possible. They need to see our bodies in the room for it to be impactful. So they know there are people, those legislators need to know that there are real humans that are being affected by these decisions.
So this is an important thing to hear. So Jill and I were a small group of people. Anne was there when the assembly had their subcommittee hearing about a month ago. And Jill's a board member. Her building went through a defect action. Simply because she works at our firm does not mean she's, somehow she shouldn't have her home protected and her rights, appropriately represented. But she got to actually speak before the assembly committee and explain her role in the community association. And I don't want to speak for you, but it shook you because the opposing side goes after the supporting side. And so we're in the room and there's we were the last one before we got to go to lunch. And so most of the room is cleared, except it's packed. We don't know why. And then they, call up the assemblywoman. She gives her song and dance on how great this is going to be for everybody. And then all the people get to go up and say, I'm the town of San Francisco in support of this bill. There was 50 people who got up there and were like, we love boo, boo, boo. And then it's Jill gets to go up to the front of the room, sit in front of the assembly. And it's the four of us in the room. And it's very
Talk about why. Who's supporting this bill? It's the builders, it's California Building Association. They're the sponsor of this bill. So when Buffwicks, in all of her well-intentioned, I'm sure she had great intentions in trying to do something good for California. I don't think this is against what she intended. What she did was she asked really only the the Builders Association, how would you rewrite the law? So she gave them pretty much carte blanche to write really developer-friendly, developer immunity, as Jasmine calls it. I think it's correct, a developer immunity bill to immunize them essentially and really strip consumer rights and remedies to hold builders accountable. So of course, who's going to show up? The Builders Association, that's a well-heeled, well-oiled machine. The developers know exactly what they're doing. And they had that room stacked of people. And I do think that the legislators need to hear from the people who are affected by what they're doing.
It was truly eye-opening and so intimidating because I really believed when I got out of bed that morning at 5 a.m. to march myself down to Sacramento, I really thought there would be homeowners there, that it was so obvious of how hard this would be if this passes for homeowners. And there's no universe in which it makes sense to imagine this makes life more affordable for people who are coming into affordable housing. It's just, but it's not obvious. And that's what was so eye-opening. And that's why we want the people who are paying attention and listening and who understand the ramifications of something like this to get up, make your voice heard. And that day on the bus on the 30th coming up next Tuesday or after next, it's going to be important to have bodies in the room who understand. So that might mean community managers, HOA professionals, especially homeowners and homeowners who've been impacted by construction defects in the past.
Oh, yeah.
Somebody's got their hand
Property managers, community managers, by and large, they're homeowners too. So everybody, this is affecting people of the state of California. And so the people of the state of California need to be aware, let their voice be heard, send in those emails, and if they can join on the 30th, I think that'd be very powerful.
And someone's asking what time in Walnut Creek on the 30th. It'll be at 7 a.m., but I'm going to send out a whole email tomorrow to everyone who's registered for this call and a long list of others. And it'll have a link to just sign up. We'll make sure you know where to be. We'll give you contact information and we'll make it really easy.
I love it, Gail. I hope you do come. It'd be great to sit on the bus with you. We'll go over 2800 stuff while we're at it.
And Anne, can you correct me if I'm wrong here, but what we do know at this point is this is gonna pass in some form. And what we're trying to do now.
So is 10007. Like, I want everybody to
asked that
hear,
too.
like, these two statutes are going to pass. This is not a function of like, oh, we're gonna full on kill these. I would love to have that confidence and be able to say that, but I don't have that confidence. Buffy Wicks is probably the second most influential Democrat in our legislature. She didn't introduce this bill so that it could fail.
Yeah.
Right.
She's the head of the appropriations committee. She controls the purse string to everybody else's pet projects and all their legislation. So I'm sorry, but there is not a scenario where this is gonna fail. We're trying to make it less crappy.
Gail
Yeah.
is asking, what's Scott Wiener's position in this? Scott Wiener, for those of you who don't know, has been a big housing advocate. He's running for Congress right now. And she said she has a meeting coming up with him. Here's what Scott Wiener needs to know. This bill will not promote condo construction. It won't promote building construction because homeowners are going to find out that when they buy that condo, they're going to have no rights to basically no warranty on that condo for anything significant. And they'll know that. And they may build them, but nobody's going to buy them. So he needs to know that this is not the kind of legislation that's going to promote affordable housing construction because it's real obvious why this is going to turn off potential buyers.
And Debbie, I saw a question from Debbie Hanna on the list that said, you know, what's the California Association of Realtors positions? I don't know their position, but Debbie's not wrong that this may result in legal actions being brought against the realtors who are selling the units because, you know, for a new build unit, you're going to have issues where it's like, hey, I didn't know I was going to be on my own on the island having to foot the bill for this crazy amount of bad stuff. Like, I thought I was buying a new home and it was supposed to work okay, and it didn't. And no one told me that I was going to be left holding the bag. And, you know, Debbie, I think you're absolutely spot on to identify that this could result in litigation for realtors who are selling the units. It leads to Tyler's problem, which is realtors are now going to be, you know, over disclosing. By the way, if this is passed, you shouldn't be buying a new build condo because you could be screwed. And, you know,
Yeah.
So these things all like go together and it's not in a good, pretty puzzle, that's for sure.
Yeah.
Yeah, there are things that could be done to make the law more reasonable. And so we are continuing to work with Buffy Wicks and her staff to reel it in. But right now, as it's presently drafted, and it's, you know, that's going to be dated, and hopefully we'll get the changes that we and the consumer attorneys of California are negotiating for and advocating for to primarily to get rid of the idea that we have to wait until the damage is done, which eviscerates most of the work that was done in 2002. And then like we were saying, like the idea that the developer gets to control the entire process and then get basically immunized from anything, butterflies to the rest of the project, that there's really no means for an association or its members to hold the developer accountable to make sure that those are quality repairs. It's really all any association wants is quality construction, and if there's something wrong, quality repairs. And really, this would make California is a leader in a lot of things. This would make California a leader in the United States. There is no other state that has such a developer-friendly immunity process for construction. It's crazy. California has always been known for its proactive consumer protection measures, and this law would make California the least consumer friendly state out there for something like this, and that's just not what we want for California.
It's funny, Anne, you mentioned quality. I said this to a developer yesterday in the context of my home and my neighborhood, and I said, you're talking about your business. I'm talking about my home.
Right.
And that's the difference in the quality of repair.
Yeah.
Yep.
So Jonna asks a good question, Anne. Will this statute, if it passes, apply to SB 800 claims that are already in process?
Well, there's a lot of negotiation on that. Currently, there isn't language yet that would make it, would restrict the entire bill as it's currently drafted, but we are working on that to make sure that it would only apply prospectively, but currently ambiguous.
Yeah. So, I mean, Jonna,
Make your voice heard.
yeah, make your voice
Yeah.
heard, because I know where you live.
Yeah.
I know what you're in the middle of. You know,
They-
so.
there's, just to clarify, there's language in the current version, which again is an evolving thing, that would only limit a small portion of it would just be the inspector process that would only apply to claims in the future, the 2027 and after, but the entire bill is not limited in that way. So the Oz problem and the property damage issue that we've been talking about would apply generally. So it still needs a lot of work, and we are doing that work with the legislators behind the scenes. So hopefully
There's a
things like
question
that.
up here. Well, go back up with Joe a little bit. Will this, no, beyond that, it's something to do, what will this do to the multifamily real estate industry when these become law? Absolutely are going to put a wet blanket
Yeah.
on the industry, because it's going to do exactly the opposite of what the promoters of this bill think it's going to do. Because it's not going to take very long before people realize that they're buying something for which they have very little rights to have corrected if there's a serious problem there. Yeah. And when the damage begins to be known, and we inspect an awful lot of buildings in this firm and other firms like ours, and we know that stuff exists and it's real. It's not made up by the lawyers, it's real. And not only is it real, it's extraordinarily expensive to repair. Fortunately, because of the way the law is now, they're able to get a substantial portions of the cost of repairing them back out of the builders. This passes, that will, as we've said several times in this presentation, that'll be cut off. And that'll leave that liability with the individual homeowners association and owners, and it won't take long for that to get out.
Just to reinforce what we were saying earlier, back from the insurance companies that the homeowners paid for in the first place.
Right.
That's what this does.
When will we know the final version for this year?
It'll be October. So the way the legislative session, it ends at the end of August. So bills are either passed or not passed at that point, and then they go to the governor, who's got about a month to, either sign them into law, veto them, or allow them to tacitly be approved. And so we'll know by basically the first part of October whether it has whether they have or have not passed. I see Hans write a question about what has Senator Wicks, is Assemblywoman, but what has her response been to our concerns? I have personally met with her chief of staff. So this is not a function of I'm just kind of braying at the moon. I've met with her chief of staff. I haven't had an opportunity to meet with her directly. I know, Anne, that our advocates have had multiple meetings with Assemblywoman Wicks and her team. And what has the response been?
Look at that last question.
Yes, we'll get to Dale.
Yeah, the response has been, good and positive in the sense that she acknowledges problems with the current bill, and she's still trying to work through them. Unfortunately, we haven't seen the big problems that we have identified fixed. There have been other things addressed along the way, and she's made certain representations that she realizes it needs a lot of work, as she says, and so we're hoping that she's going to do that. But the big part of the problem right now is that who's driving that bus, the sponsor of this bill, the Builders Association. So it's a challenge, but her response has been appropriate in that she's still working on it.
Yeah. And then Gail,
but that is why everyone needs to get on that bus that can and make their voices heard and send those emails and make sure that the elected officials hear from the people who elect them. That's what this process is all about.
Yes. And Gail, yes, we'll be in touch with you before Friday to prep you up for your meeting with Scott Wiener, the staff. So we got just a couple more minutes. Since 10:07, it has not yet passed the legislature. So it has passed from the Senate over to the Assembly side now. And so it's been referred to, the litany of Assembly subcommittee
that's how the legislative process works. I'm, poli sci nerd, so I'm like, hey, but for those who may not be steeped in it, it starts on its assembly side or its Senate side. So when we have an AB that's assembly bill, that means the author of the statute's an assembly person. So it starts on that side. It goes through all these little subcommittees. And as it goes through the subcommittee process, it either keeps advancing out of the subcommittees. Sometimes the subcommittees make the author accept amendments and changes because they're like, oh, I don't like that part of it, change it. The author of the bill then says, okay, I'll agree to this. So the 10007, just as an example, it started with a completely batshit crazy CPI inflation. So if CPI was 3.2%, that was the cap for the assessments for the year, which is just basically crazy. And so, through this, process, Senator Menjivar has amended the statute to the 8% that it's presently at. So it started even worse. It has incrementally gotten a little bit better, but still the 8% is highly problematic for a lot of reasons. So, but I did want to say, Antoinette, it has not passed. We are, definitely the thing that you can do on SB 1007, go to the CAI CLAC homepage, CAICLAC.com homepage. They have the same widget on the homepage that we have on our website, birdingwild.com. They have that on CAI CLAC. You literally just put your name in, put your zip code, and it'll, fill in the form and send it to your legislators lodging your, disapproval of Senate Bill 1007. So thank you for reminding me to bring that part of this up.
We're going to take Tyler's going to take a final question here, and then you guys can reach me later.
Carl Stonkin's asking, how would these bills apply to older condo complexes with construction defects are found like 1970s? In terms of 1903, what it's going to do is right now, we've got as good a safety net as we can get to screen out as much of this defective construction in the first 10 years of the life of the condos or any residential building that we're involved with, as much as we can. If we can't screen that out any longer because the homeowners associations can't afford the inspections necessary, more and more of these defects are going to get passed along to the subsequent owners down the line, the older condominium complexes, which are already impacted by defects that were not found early on and are causing serious financial problems for them, is only going to get worse because right now we have a bit of a safety net. We can screen out a lot of these defects. We can get recompense from the builder for them, and a lot of them get repaired and they don't get passed on. But if we can't do that screening process, because we're not allowed to recover for the cost of those investigations, those homeowners associations are just going to have to deal with them themselves, and a lot of it's going to get passed on. I think as far as the cap on the assessments is concerned, that is going to apply to all associations.
Yes. Whether you're planned development, new, old, condos, high rises, does not matter. 8% is 8% is 8%. And so I do hope that everybody, birdingwild.com, CAICLAC.com, go to both of those. It's literally going to take you less than 2 minutes. You can, lodge your email objection to both the statutes. For those who are also inclined, do the phone call to your legislators. It makes a huge difference. You're going to basically get someone who's like, well, this is Senator Menjivar's office. You're going to call and be like, I'm a constituent. I want to lodge my opposition to 1007. Thank you. And that's the amount of time that it takes. And, so it's not hard to raise your objections to these statutes. If you guys want to go on, LinkedIn or social media, tag your, assembly people, and they get to know in an additional forum you're opposed to these statutes and why. If you've lived through a defect action and you have pictures from the janky stuff that your, home or your community had to go through in getting, defect action, post those on social media, tag your legislator, let them know These are real things. This is not BS claims that are being raised by greedy plaintiff lawyers. I literally told, you know, Assemblywoman Wick's Chief of Staff, Steve, when I sat down in his office, I said, I just want you to know that if you added all of me and all of my partners' salaries together, you would not meet the salary for the, you know, Lennar's CEO. That's all of us together in the firm, still not making as much as that one person. We're not flying around on private jets. I drive a 20-year-old Lexus. You know, it's like, I said, we're literally not part of the problem. We're trying to help consumers make sure that when they sink their life savings into a home, they're not burned on the back end. And on the corporate side, because I oversee the corporate counsel team, I'm trying to make sure that my community associations are able to actually operate, that they are not forced into, you know, further legal fees. I don't want to take my clients' money because they're like, hey, can we do an emergency assessment that's like contorted and all of that? And so, you know, there's reasons why, you know.
We see a lot of your questions that we're not going to be able to get to with the time we've got allotted here. We don't know if we can get to all of them or to have a way to respond to them through this medium. But if we see questions that we can answer, that we probably could put some answers on the website if we can keep the questions.
Yeah, so you guys watch, everyone on this call, watch for an email from me tomorrow. Sign up for that bus. We'll have attorneys, and you're gonna be on that bus, right?
Make a point of it, yeah.
And she's already offered to give free legal advice on this bus. So save some of your questions for Anne on that day, put her to the test, and maybe she'll even have any updates by then as well. So watch for that email from me tomorrow. You're welcome to respond to me. If you had a question on here that we weren't able to get to, respond to me and ask the question, and we'll figure out a way to like pull all these questions and make sure people have resources to understand what's going on. Thank you guys for attending. This recording will be on our website in the next couple days.
Thank you.
Bye, everyone.
Thank you.